Ms. Bailey, your thoughts, please.
Yes, Your Honor. I have consistently made desperate efforts to take my son consistently on the days I'm supposed to get him, but Mr. Evans is a very difficult person to co-parent with, and a lot of times it turns very verbally abusive. In the past, he's physically abused. I've had to get PPO on him. He's difficult to deal with. And lately I've just been trying to just have a set schedule, and he'll like call the day after I have Tyson, and he'll do something like, just last week I was supposed to have him for the whole week. The day after I get him, he calls and asks him if he wants to go paintballing. And then the week before that, we're at his tournament and I only had him for a day, and then he invites his friends over to his house. So Tyson wants to go home. It's a manipulation. It's a game for him. He went live for 20 minutes about me on Facebook. It's impossible because he's so abusive towards me. And no matter how many times I try to be nice and get along, he just won't do it. And I have all the evidence of the abuse. And I can submit it to the courts if you would like, because
I don't need it today. Thank you. Well, Mr. Browning, I'll give you the last word. I'm not a fan of these Facebook things, so to that extent, you can advise your client to knock that off, please.
Well, that would be fine. But then generally, yeah, what my client was seeking was to reaffirm or to reestablish that parenting time in terms of what day the opposing party is supposed to have child. She has changed it unilaterally about 4 times, he says. So right now, he's kind of just dancing to a tune in that regard. I'm sure he would disagree that he's been abusive. And as you see, the file number on this begins with 10. So these two have not been living together for like 15 years, we can gather from that. So I don't think that she has a lot of contact with him. I mean, I could be wrong if this was filed originally as a child support case or if they reunited later. But when I see a case number beginning with 10, I think that it's been since 2010 that they've been having this custody disagreement. The child is also about 16, I think, which would suit a case this old. So, the child wanting to go over to his dad's because of friends and stuff is fairly normal, and a certain amount of autonomy would be normal too.
Here's the reality the court is acknowledging. This case is old, really old. A file dating back to 2010 means the court has history, context, and precedent. And with a 16-year-old child, judges do consider autonomy. Wanting to be with friends or choosing comfort isn't manipulation by default, but whether it's being encouraged unfairly is where things get complicated.
Well, I agree with you. If the other parent doesn't simply do things that would make parenting time difficult for the other parent because the child's going to want to be at their house, like inviting all their friends over, playing paintball, doing all these things. What does the order say what day it is?
The order had said Friday.
All right. So if they can't agree, you default to Friday. Very simple.
Okay.
There's no other way to, I hope parties can agree. And I agree with you, Mr. Browning, that there's been, at least from my perspective, very little by way of involvement with the court in that. There's some allegations in here that are kind of troubling, and so I can either just tell you default to Friday and then be done with it, or do you believe that enough proper cause or change of circumstances per shade has been alleged to proceed with a investigation and recommendation?
Well, Your Honor, my client is concerned about opposing parties' living situation. Since she got out of incarceration, she's bounced from place to place. None of these have been her own residence, to our knowledge. Beyond that, it's been at least 5 years, or possibly 7, since the last time that child support and parenting time were reevaluated. So this
All
case
right.
is eligible for that.
Well, and I just want to point out the fact that I understand that when you have a sheet, so to speak, it becomes a little bit more difficult um, to secure places.
Yeah.
But I think what I'm going to do is this. I'm not going to make any changes today, but just reiterate that the parties, you follow the old order until it's changed. But I do believe, pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2010 case, that the more expansive definition of proper cause or change of circumstance has at least been alleged, and I do find probable cause. Obviously, poor communication and lack of cooperation between parents is always a change of circumstance, revisit parenting time, because as stated in MCL 722.23J, it diminishes each parent's ability to encourage a close and continuing relationship. There's other issues too. Obviously, there are mental health issues, drug issues, non-payment of support, that issues such as stability of residence, which puts into question MCL 722.23D as in David. So I'm not going to make any changes today, but I'm going to grant your motion in part, Mr. Browning.
This is a turning point. The judge finds probable cause under Michigan law and orders a full investigation, not just into parenting time, but child support, communication failures, mental health concerns, and housing stability. Nothing changes today, but everything is now under a microscope. This is how courts reset long-running conflicts without rushing judgment.
And I'm going to refer the matter to the Kent County Friend of the Court's office for a complete investigation and recommendation into the issues of parenting time and child support. And the fees for that will be paid by your client. So I can assure that this case will not be administratively lost and we have to start over. So, but you can prepare an order also that says the current schedule, unless the parties agree in writing, will be followed pending the investigation. Okay?
Okay, one last thing then. I just want to confirm with the parties that their understanding is that the original date way back when was Friday, last that it was put in place by the court. Is that your understanding, Autumn and Jovan?
Yeah, actually, I've been trying to get him on Fridays, and Javon has been giving me a hard time about that. So I tried to get him the last day of school, and he told me no. I have the text messages for that too.
Okay. But Friday at like 4, 5, 3, what do you guys?
Whatever the order says.
All right.
And also, Mr. Browning, I'm not going to order it at this point, but I would like you to discuss with your client and the possibility of using our family wizard. Maybe that would help with the communication issues going on between the parties. This thing hasn't been looked at since 2018, and we'll see what we can come up with there. So I'll do the order of reference today.
Excuse me, Your Honor. Can I say something, please?
No, the only reason that is this, Mr. Evans, is when you're represented by an attorney, your attorney does not want you talking to me directly, because even though it may be something very innocent, it could affect your case. So what you should do is ask or talk to Mr. Browning, and if he thinks it's something that needs my attention, he'll bring that to me. But I'd love to talk to you all day, but your attorney would slap me right through the screen if I started talking to you. Okay?
Okay, Your Honor.
All right, you're
I
all
wouldn't
set.
dare for real, but maybe you, Javon.
All right.
Okay, so when does it go in hand? Because like I said, I don't know the parenting time because she's never followed it. So
Well, contact your
So-
attorney and he'll
Okay.
tell you what the last order is. We're going to follow that unless the parties agree in writing. Okay?
I don't want no contact. So
So that's how it is. So
Okay.
we are adjourned, and I wish you all a safe 4th of July.
So here's where this case lands. No immediate custody change, the original Friday order stays in effect, and the friend of the court steps in for a full investigation. The judge sends a clear message: ongoing conflict, poor communication, and instability can justify reopening even decade-old cases. Now we want to hear from you. Who do you think handled this situation better, and what would you have done differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.